to love and to cherish, until we be parted by death.
These are the words most married couples try to abide by once they are married. Immediately after solidifying that union, they want to live together happily ever after until death takes away one or both partners. But that was not to be for James Mwangi Wachira, who has now been divorced for 2 years.
Makosa ilikuwa ni kukosa pesa. Naye akapata pesa. Akaona hazipelekana mtu kama mimi. Akaniwacha.
James got married in 1996 at a church wedding in Gatito village, Nyeri County. He had big dreams and hopes for his family, whom he intended to protect and provide for at all times.
Ilikuwa ni madharau. Kwa sababu wakati la kwanza nilileta 50, wakati huo pesa ilikuwa mingi. 50 ilikuwa mingi. Nikaleta 50 akaitupa chini. Nikaleta 100 akaitupa chini. Lakini sikujua ana mahali anatoa pesa nyingi kuliko vile mimi namletea.
And with that, he decided to call it quits, saying as he was no longer able to keep up with his wife's demands. One may be excused to conclude that Wachira's scenario is one that allows for divorce by agreement or consent. But according to Christine Kungu, a legal counsel at FIDA Kenya, that is not the case.
There's this notion that some Kenyans have that you can file a divorce by consent under the Kenyan law. This is in comparison to the American system, whereby a party to a marriage will go to the other party and ask them to file certain papers, to sign certain papers, and by consent, that marriage will stand dissolved. This is not applicable under Kenyan law. You cannot file a divorce by consent of the parties. You have to file what we call a petition.
So what exactly is a divorce petition?
A divorce is a formal process whereby a party to a marriage moves to court to specifically ask the court to annul a marriage or dissolve the marriage.
The Matrimonial Causes Act only allows the dissolution of a marriage on 4 grounds, and that is adultery, desertion, cruelty, and where one party is of incurably unsound mind. The divorce process could either be a short or a long process, depending on the unique circumstances of the couple that seeks to dissolve their marriage.
Upon filing the petition in court, the respondent, that is the person being sued for the divorce, will be given 14 days to file his papers or her papers in court contesting that divorce, or if they're okay, they're consenting to that divorce, they're also free to state to the court that. Then after that, the normal process of the court takes place. The petitioner is given a date for hearing, whereby you have to come and prove to the court the grounds that you're alleging are the cause of you filing for a divorce.
Matters of property and or custody of children may arise in the situation, and Christine Kungu says different scenarios are catered for by the law.
You specifically request the court to determine the issue of divorce, and the other 2 courts, the Children's Court to determine the issue of the children's, and matrimonial property to be determined by the High Court, so that there's clear jurisdiction on all the 3 areas.
Okay. That said, Article 45, subsection 3 of the Constitution states that, and I quote, parties to a marriage are entitled to equal rights at the time of the marriage, during the marriage, and at the dissolution of the marriage, end of quote. This simply means that whatever is acquired by a couple during the marriage should be shared out equally in the event of a dissolution of that marriage. But James Mwangi is of the opinion that the court process is long and expensive, and all that matters to him is maintaining a cordial relationship with his children. Reporting for Citizen Weekend, I am Kirigo Ngarwa.